Speaker and honorable members, for the record, my name is Jacob Ngwele. I'm an advocate of the High Court, and I'm appearing with my learned senior, Mr. Nyoka, who is leading me on this particular matter. Honorable Speaker, perhaps we can get guidance from your end. How much time do we have on our side to respond to these issues so that we can have guidance?
How much time do you need?
We need at least 2 hours.
That will be a lot. You will only, because the members will have another exercise, allow me allocate you. Let me confirm.
We'll be seeking guidance from the chair. We're raising a few points of what we find low notice of preliminary objection. Certain objections on the motion, that is on the legality of the motion, and we'll be seeking guidance from the chair. The first one, of course, is founded on standing order number 65. That is of the standing order number 65, 1A of Nyamira County government. That is on the issue of right to be heard. That is Nyamira County Assembly standing orders 65. Honorable Speaker, even though the substantive procedure is governed by standing order number 62, there is standing order number 65, which provides the general guidance on all matters for impeachment, be it impeaching a CSC, a governor, or a member of the County Public Service Board, or any other person. So that standing order talks about the right to be heard, which we agree we have already been given that opportunity, and that's why we're making these submissions. However, Honorable Speaker, I'll take you to standing order number 1A, which talks that, which reads that, which requires the County Assembly to consider the petition or approval for the removal of a person from office. The person shall be entitled to appear before the relevant committee of the County Assembly, considering the matter. That is a requirement, a legal requirement, and your standing orders. So here we are on the plenary, but we have not been accorded an opportunity to appear before the relevant committee. So basically, these proceedings ought first of all to originate from the, even if the motion is tabled in the Assembly, there ought to be a committee of the Assembly to consider. And if you go further, you will see that the Assembly to hear a person on the ground for removal, then on the date and the time to be determined, there's also the issue that, number 2, the person being removed from office shall be availed a copy of the report of the select committee. So once the committee has sat down and dispensed with this business, then the person being removed ought to be accorded a copy of the report of the committee, which you have not been afforded to. So we'll seek guidance from the chair whether this standing order has been waived or is inapplicable, so that we can get guidance as we proceed. Secondly, on the other issue I want to raise is the issue on standing order number 87. Standing order number 87 of the Nyamira County Standing Orders talks about issues of sub judice, matters which are sub judice. And it says, no member shall refer any particular matter which is sub judice or which the operation of the law is secret. So sub judice, so no member shall refer in the House, whether in the plenary or in the committee of the House, a matter which is sub judice. Of course, the same standing order gives the standards of what constitutes sub judice. It says, a matter shall be considered to be sub judice when it refers to active criminal or civil proceedings. The discussions of such matter is likely to prejudice fair determination of that matter. Honorable Speaker, if you look at the notice of motion which is before the House, I'll refer you to grounds. I'll refer you to the first ground, that is ground 1A. That is ground 1A and B. Then you will also, the same one is also repeated in
the whole House. And today you are facing the committee of the whole House of the County Assembly of Nyamira. So you are at the right place. Consider this as a committee. The report you received had annexures and every detail that you are here to respond to, a special committee that was chosen by this county assembly, that was financed by this county assembly to come up with the same draft that you were served. So you have the right document that is approved by the Speaker of the County Assembly. Above all, Standing Order number 1 gives all the powers to the Speaker to direct on how the matters should run as per to your allegations. As per to the active matter in court, we have not been served the same to stop this county assembly from debating on any such a matter. So the county assembly is equivalent to the High Court of Kenya, with the powers also to deliberate on the very same issues. So we give you an opportunity to respond to the same allegations. Thank you and welcome.
House are brought pursuant to Article 181 of the Constitution, which provides that, which gives the Assembly the power to remove the governor from office. The grounds for removal of a governor from office are well provided for under the said provisions of the Constitution. Number 1, there must be a gross violation of the Constitution, and just to zero in on the other one, abuse of office or gross misconduct. So these are the grounds which have before this particular assembly today. Our submission is that the motion before this particular house does not meet the threshold which has been established under this particular constitution provision. And we will endeavor in our submissions to show and exhibit the house that this motion has not provided evidence that these charges have gone through. The standards for hearing or measuring this particular matter was set in the famous case of Wambora and also in the Sonko case. So it's not about a violation. It's something must be gross. Gross breaking of the law. Gross is not a traffic offense, a minor miscreation of the law or anything. Gross has been defined as something shaking, something on the face of it is bad. It is bad. So we need to submit that this motion has not disclosed any evidence. The motion does not meet the legal threshold of Article 181. Number 2, there must be a nexus between the governor and the alleged violation. For this house to make a determination, you must ask yourself, is there a nexus? A nexus means a connection between the individual action of the governor and the alleged violation which is being alleged. And the violation which must be established in a substantive interrogation of evidence. So for you members to find out whether the governor has violated the provisions of the Constitution as envisaged, there must be substantive evidence placed before you to show a nexus that these actions were the individual actions of the governor. It's not an institutional issue or the government did what. It must be an individual action of the governor. We do submit that as we are going to exhibit, that no nexus has been exhibited in this motion to show the linkage between the alleged action and the conduct of the governor. Number 2, no evidence. The charge and evidence do not provide the link to the governor on any of the grounds. So, based on that submission, we are going to submit on 2 things. There is no nexus, and the charges do not meet the constitutional threshold for impeachment of the governor, such that there is gross violation of the Constitution and there is gross misconduct. I'll invite Malanet Senior to lead this house on the first, on a few grounds, then I'll take over from there.
As you said, can you guide my honorable members on what, on your case, you find to be gross and what is just a normal violation?
Thank you very much, Honorable Speaker. A normal violation of the law is a violation which, a gross violation, there must be an intent. You must look at the criminal aspect. You must look at is there a deliberate attempt? Is there a deliberate attempt to defeat the law? That deliberate, that mens rea, that is the criminal intention. It may be like something like misappropriation of funds. There must be elements of misappropriation of funds whereby it is evidence is brought that there was a cartel which was formed, or maybe there was a scheme to defraud funds. This is what amounts to gross violation whereby, but the other violations are whereby the county has not complied on one. There are small violations of the law here. These regulations was not conformed to. This is what it means, normal violations. And in those normal violations, you cannot impeach the governor. And again, this gross must be as a result of the individual action of the governor. You cannot load the governor on the county public service board did not do this, then the governor bears the responsibility. That is not gross. There must be a nexus between that. I hope I've guided the House.
Thank you for that information. Honorable Nyaribo, Deputy Speaker.
Point of inquiry, Honorable Speaker. Mr. Speaker, that the lawyer is not seeing criminal action anywhere in that motion. But I wish to know whether he's seeing unethical actions in this motion, in the governor's actions.
Thank you. Let's allow them preside. Have a note.
Speaker.
Turn your mic on, please.
Mr. Speaker, sir, and honorable members of this House, I have the privilege to appear on behalf of His Excellency, the Governor, and in my submissions, I specifically restrict myself to the issue of public participation. Honorable Speaker, the issue of public participation is so central to any impeachment proceedings. In that regard, I refer the members to Article 196, Sub-Article 6, as read with Section 87 and Section 81 of the County Government Act. These particular provisions, Mr. Speaker, they are designed to give effect to the national values and the principles of governance. This includes the element of public participation. Why is this so, Mr. Speaker? Then this takes us back to the articles and the pertinent articles of the Constitution. And in that regard, I refer the members to Article 1 of the Constitution, which provides that all sovereign power belongs to the people. However, that power must be exercised only in accordance with the Constitution. Then, Sub-Article 2 goes ahead, that is B, that this sovereign power can be exercised directly or through their democratically elected representatives. But then these elected representatives have an obligation to act only in accordance with this Constitution. Your Lordship, Mr. Speaker, if you go ahead and look at the provisions of the Constitution, Article 2 of the Constitution, it's very emphatic that the Constitution is the supreme law of the Republic, and that it binds all persons. It binds all persons and state organs, both at the national and at the county level. Mr. Speaker, if you go further to Article 3 of the Constitution, it goes ahead and says that every person has an office to public service board, Mr. Speaker, runs its own budget, with its own budget and its own secretariat. Section 30 speaks about the functions of the government. Section 31 spells out the powers of the government. None of this gives him power to exercise any control over the county public service board, which has the sole discretion and mandate to deal with the issues recruitment, staffing, discipline, etc. Mr. Speaker, if you look at the entire motion, the petition has not demonstrated how the governor, jointly with other officers or the chair of the County Public Service Board, has usurped the functions of the secretary of the board. Mr. Speaker, you look at that same ground and the evidence that has been submitted. The mover of the motion has not shown the nexus between the alleged gross misconduct or violation and the conduct of the government. The mover is on a fishing expedition, made allegations so weighty that must constitute removal of the government, but has failed to table or to cite the particular charges and the evidence supporting the charges. Mr. Speaker, you look at those allegations. There's no element of personal knowledge. It has not been shown that there's personal knowledge on the part of the government that this is what was happening in regards to these particular officers who have been cited in this petition. The charges, Mr. Speaker, as framed, do not disclose any culpability of gross violation on the part of the government. The petitioner is on a fishing expedition. Your Honor, Mr. Speaker, further on ground 1B, that is on the issue of right, the issue of denying students their right to education. Mr. Speaker, the mover of this motion has cited ground Article 29, sub-Article 4, as the relevant provision that has been violated by this particular allegation against the government. That particular proviso or article of the Constitution does not support the allegations of violation of that particular ground, that is ground 1B of the motion. Why are we saying so? Issues of education and rights of education are captured in Article 43 of the Constitution. But nonetheless, we said that there's no violation on the part of the government. This action of the government of the state was taken out of context in terms of the language used. However, whatever action and whatever step that the government undertook is provided under the Education Act. That is Section 2 of the Education Act. I invited the Assembly to look at our annexure 2A, that is on the Nyamira County Education Support Act 2016, more specifically on Section 2 of the same Act, whereby at the very end of subsection 2, it says, student means any Kenyan and a voter or whose parent is a voter in Nyamira County. Any matters of education, including disbursement of bursaries, is limited to residents of Nyamira who can only demonstrate with the residents to a vote. The only option The only option that the move of this motion has is to challenge that particular section which the government used to decide the criteria that was used to disperse funds or bursaries to meet students. It should also not be, we should also not lose sight of the fact that this is a common practice. It happens in all counties. Remember that resources are appropriated depending on the number of residents in a particular county. So dispersing these resources without a criteria of identifying who are the bona fide residents of a particular county, that shall deny bona fide and the true needy students of that particular county. We submit that there is no violation. We acted well within the law. Mr. Speaker, let me proceed also to submit on ground 1C, that is on ground 1C, that is on the issue that is on violation of the Nyamira County Mortgage Scheme Fund, regulations and the Nyamira Car Loan Scheme, and regulations by benefiting from unsecured car and mortgage loans. Mr. Speaker, could the mover of the motion have exercised some further due diligence, even to make an inquiry? Then this could not have formed part of the grounds of this particular motion. Mr. Speaker, Mr. Speaker, on the issue of car loans, that is an issue that will be addressed by my colleague, to address the issue of people with disabilities. Your Lordship, your Mr. Speaker, the issue of people with disability is provided under Article 54 of the Constitution. The government, and by extension the government, prepared a bill to operationalize issues to do with people with disability. We have annexed that particular bill. The bill is pending before the Assembly. I shift or push back that responsibility to the Assembly, which has failed in its legislative mandate by debating and enacting that particular provision, which is pending before the Assembly. We have annexed the draft regulations in regards to people with disabilities. Mr. Speaker, that notwithstanding, through magnanimity of the governor and with his executive, they have nonetheless provided some budget to address or to operationalize issues concerning people with disability. Despite lack of cooperation, lack of expeditious act or action on the part of the Assembly, they nonetheless provided a budget for that particular provision or function of the county executive. It's also worth noting that Nyamira, as a county, is one of the pioneer counties which commenced the process of enacting that bill. I expected the move of this motion to applaud and congratulate the county executive for that particular move, which is far ahead of other counties which are lagging behind in making efforts towards the realization of any acts or laws concerning the affairs of people with disability. And without this particular regulation, the appointment of the board and subsequent operationalization shall require budget allocation. How shall the executive be able to manage if the board is put in place? How do they
see provisions of the law which are not that because you have not achieved them, then you've grossly violated? This is what I was categorizing earlier between gross violations and issues which are in the law, which are progressive in nature, which are just requirements. That even the requirements of standing orders as you have. So such a violation cannot be. And in any event, the issue of the wage bill, we do submit, there is no nexus. There is no something that the governor has caused. This wage you have in the county, the number, the wage bill you have over and above, has not been the origin of the governor. The wage bill we have in the county is as a result of successive governments since the devolution. Number one, the overemployment is the result of the first-term governors, and also the issues of employment which have occurred over a period of time. This is the third cycle of devolution. All the employments which have been done within the first and third cycle cannot all now the governor carry the burden that you have violated. Your wage bill is a result of that. The other issue is that what is not known is that at the beginning of devolution, even though the county government had a lean staff, most of the staff were devolved from the national government, which also was not contemplated, which has led to the rise of the wage bill. Honorable Speaker, the issue in the motion, the specific allegation in the motion was that this assembly in 2021 had passed a resolution that there were more employment. There was a freezing. And that is what is mentioned in the motion. Honorable Speaker, we wish to controvert this allegation and we say that we have provided in our bundle of documents Annexure 4A. If I can lead members, in our bundle of documents we have annexures. We have Annexure 4A. Annexure 4A, whereas the motion says in 2021, that is through a letter reference CAN, that is the 2021 letter, the county assembly had sought to freeze new recruitment. Because the motion is that the governor has violated and proceeded to recruit without the approval of the assembly, through the budget approval or any other approval, and that the assembly had already frozen their approval, that recruitment. Whereas, if you look at our letter, that is Annexure 4A, you will see it's a letter dated 17th July 2023 from Daniel Orina, that is the clerk of the assembly. This is letter conveying the resolution of the House, that this assembly by itself went ahead and authorized the governor to conduct recruitments. And it's in the letter. You can read the letter with reference. The assembly has resolved as follows: proceed with the recruitment process as you had planned earlier. And you are advised to conclude the placement process. So, this is the same assembly authorizing the governor to continue with the recruitment process. Then now the same assembly wants the governor to be out of office for violating the resolutions of the assembly of 2021. Yet this resolution is made in July 2023 when in the course of this particular assembly. Honorable Speaker, we say this allegation is not substantiated. The governor, if the governor went ahead and proceeded in exercise, not even the governor, because the other issue is that the recruitment is also not the work of the governor. It's a work of the executive design through the county public service board. So why should the governor now carry the cross for actions of the board in recruitment? If the board is within its exclusive mandate, the board is supposed to act independent. Independent means The board should not act with any directions of anybody. That is what the law provides, and the assembly has already approved it. Why then should the governor now today be impeached for violating the assembly? That is one of the issues we are raising, that this motion fails on that particular ground, and there is nothing. If the governor is going to carry the cross, then he should also carry the cross together with the assembly, which passed the same resolution. The other ground, Honorable Speaker, is the issue of wage bill. What is this we call wage bill? The wage bill is not about the numbers of the employees who have been hired. It is the quantum, it is the totality of the salaries being paid. What has led to the increase of the wage bill? Honorable Speaker, in our submissions we have exhibited that, number one, the housing levy has increased the wage bill of the county. The wage bill is 35% is measured against what? If you start with 35%, then the following year the national government increases the housing levy. So you're already at 35%, then the national levy comes in. It goes to 35.5. That is the act of national government. The other issue which has come is this issues of salary increments. They are there. The SRC last year issued a circular which increased the salary and reviewed the salary of all the employees within the county. That one also increased the wage bill. The other issue is that the fuel cost variations, increment of NSSF contribution, NHIF contribution has also led to the increase of the wage bill. The other issue is the issue of the doctors' strike. We have attached in our documents. We just want to be, the governor is not evading oversight from the House. What the governor has done, he has brought the record straight to the House. And all the record is contained in our annexure. There's an annexure 4B. This is approval of risk allowance and additional emergency allowance to employees. SRC has issued a circular increasing certain allowances. Does it have a bearing, an increase on the wage bill? Of course it does. Annexure number 4C is a CBA. Recently there was a strike of all the doctors in the county, and they signed a CBA between the county government of Nyamira, Kenya Medical and Practitioner and Pharmacy. Of course all the members have hospitals in the world. The doctors have gone back. Why did they go back? Because there was a CBA, which is a collective bargaining agreement, which has gone ahead and increased. It has a bearing. That's why the governors were holding ground. They were saying, no. Whatever you are proposing on the table is going to have a bearing on the wage bill. You cannot sustain it. But because of the doctor strikes and everything, then the CBA was signed. On the 35%, where are we now? We are on 38%. Because the doctors and their salaries and allowance, it takes upon it. There was also a return to work formula. Collective bargaining agreements, we have also attached so many documents between the pharmacists, there's a CBA between pharmacists. All these documents are provided for. All these documents, all these ones. There's also additional funding implication of emergency call for health workers. We have provided the circulars in our next years. Implementation of phase 1 remuneration. In August 2023, the SRC increased the salary of all the employees of the county. What does it have? It has an impact on the wage bill. So how does it have to do with the governor? Of course, the issue of the wage bill is an issue. And what steps has the governor done? In our submission, the governor is making steps. He has consulted the Institute of Human Resource Management to assist the county in rationalizing the issue of the wage bill. They have done steps: reversal of irregular promotions, dismissal of staffs with fake degrees, with the help of county assembly, stoppage of unnecessary employment, with exemption not taken course, so that the governor is working. This letter shows that the governor is not acting alone, is acting in consultation with the county assembly. So they agree with the relevant committee of the assembly. These are the emergency areas we need. Can we hire? And then the assembly gives approval. So the governor cannot be sacrificed for that. So that one we've submitted. Of course, we've also mentioned there is also worth to know that the county has got over 700 lower cadre staffs whose impact is minimal in attainment of the county objectives. And this can only be used as office messengers and the rest. So the county has got these historical challenges. And these are the historical challenges which the governor requires the wise wisdom of this House to assist him on how to tame the wage bill. And that process is ongoing as evidenced by the correspondence. Honorable Speaker, I'll move to the second point. The second point is on violation of the county mortgage regulations. Honorable Speaker, at the outset, this allegation does not contain the specific violations. Every offendee in this country, even if you are charged for traffic offense, you are given the ground, the specific provision of the law you are violating. If you look at this motion, it just says violation of the county mortgage regulations. It doesn't give the specific area. Which regulation is it? How was it violated? It does not even give the evidence. It does not submit any evidence. It's an allegation which has been thrown in and which is supposed now to be gross violation of the law when it does not specify the specific violation, does not even provide evidence or material. What they have given is just the regulations. The document which is there only submits the copy of the regulation. However, the governor is not evading oversight. What he has done, he has provided that evidence to show that the mortgage that he was given, it was not him who gives himself mortgage. Members of the county assembly don't give themselves mortgage. The mortgages are given by the car loan and mortgage committee. The executive has got similar committee. The mortgage is a benefit, Honorable Speaker. We have attached our regulations here. It's a benefit from the SRC. We have a next regulation here, in our next year, to show that this benefit is a benefit which the governor is entitled to. The procedures are in that regulation from the SRC. The governor, just like anybody else, just like members here, is entitled to make an application to the committee. The committee processes the application, and if it finds you have merit and you're entitled, the committee is the actor, is the architect. A scheme that the governor is the actor and devised a scheme to pay himself. Then a question arises: who manages the payroll of the county? Is it the work of the governor? Is the governor the payroll manager? Is an MCA, a member of this house, a payroll? You receive a payslip like everybody else. Whatever is put in the payslip, it is the work of the payroll. So we're not running, we're going to explain that there was nothing. But we just want to put the record clear that before you make an allegation against a particular person, it's very important you find the nexus between that particular person and the payroll, because the payroll is managed through integrated payment system. It's called IPPD. There's a system which manages the payroll, and it has got its own protocol, and the governor is not part of the protocol. So he cannot be accused that he has devised a scheme to pay himself. Yes, it's true the governor was paying arrears, Honorable Speaker. It's true. Let's go on the record that the governor was paying the arrears complained of. But how was he paid? Honorable Speaker, in 2017, we have attached a gazette notice, Annexure 6B. In 2017, the SRC gazetted salaries for members of the county government, the governor, the MCAs, and everybody. And those salaries, they downgraded the salaries of governors, MCAs, and members working in the county. What happened is, the members of the county assemblies, through the county assembly of Mombasa, through the county assembly service boards forum, that is the Kakamega County Assembly, they filed a case in court, and we have annexed Annexure 6A. That is the judgment of the court, the decree which declared this gazette notice null and void. So what happened is that the governor's salaries and MCA salaries were downgraded. So thereafter, the salaries, that gazette notice was quashed. It is quashed, members reverted back to the 2014 gazette notice. The 2014 gazette notice had higher salary than what the members were being paid and the governor. This happened across the board. So it's not only the governor alone, even the MCAs of the last assembly, those ones who are here, they are familiar with that scenario. So what happened is, the salaries had to be adjusted upwards to reflect the new reality. The salaries now had to be adjusted. They had to be adjusted. Who does that? Is it the governor or it's a HR? It's a HR, the payroll. The one that did across the board. In the assembly it was done. Members, after a while, they saw their pay slips have got arrears. And that is what actually happened, and that's how the governor was paid. However, this issue went to the ESCC. And when the ESCC was seized of the matter, they wrote to the governor a letter. It's annexed 6C here. We have annexed the letter. Refund pending conclusion of investigation. The ESCC saying, okay, we don't have a problem. The governor is admitting the money was paid and everything. Can you refund the money first, because we have realized the calculations and the computations were not done proper. It's not him. The people are doing the computations. It's just like members here. That circular had challenges like in the assembly. It said members are not supposed to be paid this number of committee sittings. So later on, the assembly must go back and recompute your sittings for 2 years. There are bound to be errors. You'll find members who have been overpaid and members who are underpaid. So SRC said, if there's a question of this amount of money, the whole of it, can it be refunded to the ESCC pending the investigation? And what the governor did, he was given a bank account for the ESCC. We have annexed a remittance, a bank transmission, where the governor deposited the money. There's a bank slip at 6B, where the governor gave the money to ESCC pending investigation. The ESCC in the letter they have said, please remember, it is the DPP who will prosecute anybody if we found out anything was criminal done with the advice of the ESCC. Here the governor is being prosecuted when the matter is before the relevant agency. So the House is being called upon today to prosecute the governor when the matter is pending before the ESCC, and the ESCC said, we will find any criminality on anybody, we will recommend to the DPP to prosecute. So does this House have that jurisdiction? But these allegations are there. The money was returned. The other issue was that payments to other officers who are there. We have mentioned, we have issues of payments to, irregular payments to, that is irregular payments to Geoffrey Kirogo, Emelad Kemuto, and 3 other county officers. These officers were charged. Honourable Speaker, these officers were provided in 6E a charge sheet whereby these officers who were paid money. So the government paid the money. The money was actually paid like everybody else. These people earned, they received money paid through the system. So they were charged because the issues were, oh, you have defrauded. What happened? The charge sheet we have attached. In a next chart, 6F, Honorable Speaker, is a ruling from the magistrate courts where the Director of Public Prosecution has entered something called nolle prosequi. Means I've charged you, but I'm withdrawing the charges against you. So these charges against Godfrey Kiriango and Mochache, this one was withdrawn.
What is your point of order, Honorable Thaddeus Nyabaro?
Mr. Speaker, I'm standing under standing order number 29 for the sake of avoiding any unconstitutional, as the governor's team is remaining with 15 minutes. Mr. Speaker, I wish that the county assembly to extend its sitting time, Mr. Speaker, because I can see at around 12:30, Mr. Speaker, that's we are supposed to, but I wish that we have to extend time, Mr. Speaker. I call upon the Honorable Nina Riech, leader of minority, to second me. And Mr. Speaker, since the standing order says, unless the Speaker, for the conveniency of the county assembly, otherwise directs, the county assembly shall meet on Tuesdays and Thursdays at 9:30 a.m. and adjourn at 12:30 p.m. and at 2:30 p.m. on Tuesdays, Thursdays. But more than one sitting may be directed, Mr. Speaker. I invite you to 29.4. A motion under paragraph 3A shall be moved at least.
Fraudulent, erroneous, or anything, the governor is not a payroll manager, so for him to bear that responsibility. However, we have said nothing criminal was perpetuated with respect to these particular individuals. They were taken to court. We provided a charge sheet. The right forum for them was to be in court. For them, if there was criminal, if there was any criminal done, then it was the courts to establish that through the DPP. But the DPP withdrew the charges against these particular individuals. Again, this matter is not even over, Honorable Speaker. As early as we have annexed 6G and 6H, this matter is pending before the EACC. We have annexed a letter dated 26 July 2024. This is as recently as 2 months ago, whereby the EACC has listed the same individual. Of course, the name of the governor is not there as a recipient, but these other individuals whose payroll numbers were provided and the amounts allegedly they paid, their numbers are there. It said to facilitate the investigation, please give us the employment files, give us the pay slips and the payroll schedules. This matter is before the EACC. Can anybody carry criminal responsibility when the matters are still in pending investigation? Does it amount to gross violation of the law when the matter is under investigation? Even members of the assembly can also be investigated. Anybody can be investigated. But at what point does the liability arise? It's at the conclusion of the investigation. It's upon the conclusion of the investigation and somebody has been charged and the court has convicted that person, then you can rightfully say there was a scheme devised to defraud. There was no element of fraud here. This allegation does not amount to gross violation, the abuse of office, because the governor is not a payroll officer. If by the end of the day, the court establishes there was a scheme at the payroll department to defraud the county, the people will bear responsibility will be the people who are managing the system. They are the people who are managing the APPD system. It's not the government. So that is because that is the individual. Abuse of office is on the person who is having that particular office where the abuse has been committed. You cannot carry the entire burden just because a driver has caused an accident or he has defrauded fuel. You say the governor should bear responsibility for that. What the Constitution contemplates are individual actions of the governor. The gross violation must be the governor himself violating that particular law. Honorable Speaker, and as we have done, in our bundle of documents, we have systematically controverted every allegation here. These allegations which don't have any legal basis, they don't have any evidence, they are not supported by any evidence, they have not even been substantiated, and on the part of the governor, he has exhibited that nothing wrong has been done. So the standard under Article 181 of the Constitution does not apply here because there's not even a single violation. I'm not even talking about gross violation. There's not even a single violation which has been demonstrated in this petition. And with that, unless the chair has got any questions from us or the house or somebody, or anything clarification, we will adjourn, we will rest